I want to give you an example of one of the aspects of drug cases that the public needs to be aware of. For example, if you're driving in your car and there so happens to be drugs in the car, there are a myriad of offenses or defenses that are available to you if there are drugs found in the car that you're driving. Let me give you an example of some of the defenses that might be available to you in this hypothetical situation. Police officer pulls you over. He needs something called articulable reasonable suspicion to justify the stop. And what that means in Georgia, under the Fourth Amendment to the United States Constitution, is the officer needs to come in pre-trial and articulate to the court his reason for suspecting that you might have committed a crime or are about to commit a crime or somebody's life is in danger. So what that requires of the individual officer, unlike Alabama, which would have the motion to suppress in some instances during trial, we have it pre-trial. And the judge would hear from the police officer. My clients don't take the stand 99.9% of the time in the motion to suppress. And we hear the officer describe his justification for the stop. The judge, for his role, needs to think that it's reasonable. So a lot of times we start initially with a determination to stop the moving vehicle. The officer approaches the vehicle, and they're very good at convincing the public to somehow, some way let them into the car. But the truth of the matter is, under Georgia law, the courts require that the officer have probable cause to believe that contraband exists in the car. Probable cause means that more likely than not there's contraband in the car. Sometimes, in some instances, clients waive that, and as a result, the police officer gets permission to enter the car. That's called consent to search. But let's say there's no consent. How did the officer get in the car? Or if there's an instance where there is consent, was the consent coerced? There are open air searches in which they walk a dog around the vehicle in some instances. In some instances, the officer tried to articulate that they smelled the odor of a controlled substance. But in truth, we look at the aspect of the police officer trying to get in the car, and did he have a lawful reason to get into that vehicle? And those are the questions that we're going to ask. Once the contraband is found, it becomes a factual defense. Whether or not somebody else had access to that vehicle. In instances where the owner-driver is the person who is caught with the contraband, the prosecutor might try to bring in evidence, well, if he owned the car, then he must have possessed or owned the drugs in the car. In that instance, as long as you could show somebody else might have had access to the contraband in the car, something called equal access, where if two people have access to the same area of the vehicle, then that contraband might be the person who was riding or had access to the vehicle. In that instance, the jury should acquit.
We're aggressive from the moment you walk in the door until your case is resolved. Our goal is to get your case off, is to get the drug case dismissed or get it reduced to a non-felony and keep you out of prison. We use all our resources available. We understand the state has tons of resources available. The government has unlimited resources to prosecute you, and drug cases are prosecuted more seriously than probably any other crime. And our job is to hit them every step of the way and do anything possible to show that their search was illegal, whether the warrant was illegal, whether the stop was illegal, and our job is to attack everything done at the crime lab, everything done by the police to try to get your case dismissed.